let's take Sarati, Freilich, and McCallum, please. Let's have those folks come up. And then we're gonna close with Kretzinger and Jefferson. I'm gonna print another denial, if you guys wouldn't mind doing a caption on that last one. Okay. Okay, can I have everybody raise their right hands, please? Do you solemnly swear or affirm that any testimony you give today is the whole truth?
Yes, please.
Okay, thank you. Okay, I'm just standing to stretch. My chiropractor tells me I sit too long and I'm hurting my back, so I need to remember to stretch. Anybody's welcome to stretch right now. Okay, Ms. Freilich, I'm gonna give you about 10 minutes to tell me whatever you want to tell me about why I should deny those protection orders. But I just want to remind you the standard of evidence is there's been a substantial change of circumstances, and this will never, what they say occurred, whether I agree with it or not, will never occur again, and here's why. Or this never occurred, and here's how I can prove that, okay? I'm gonna go ahead and give you 10 minutes, and you can go ahead and give me your testimony, okay?
So number one, I'm a QUID, which is a qualified individual with disabilities, and none of them are QUIDs. So in order to have a harassment charges, you have to be a QUID, and each one of these people he's a superintendent and those two are directors, and they're all required to take harassment classes. And I've done public requests, and they're not taking their training. So if they took their training, they would know what harassment meant, and they wouldn't have filed these charges. And then, so going on what Scott put on here, past incidents, Kathy was a former employee at WSSB. That's not harassment. Kathy resigned in lieu of disciplinary action, and that's a lie, and they knew that at the time that they wrote that. And I have, we went to, so they're vindictive, and so I quit my job in order to stop the harassment, retaliation, discrimination, hostile workplace, and Anne went ahead and disputed my unemployment. So when they did that, they got themselves a lawsuit. So when they disputed my unemployment, it went to court. It took 1 year, so I had 1 year with no income coming in. Could have lost my house. Lots of things could have happened because they're vindictive and they lie. So on the court order, it says that I won, and it says, the testimonies of the parties conflicted on material points based upon the evidence presented, and having carefully considered and weighed all the evidence, including the demeanor and motivations of the party, the reasonableness of the testimony, and the totality of the circumstances, I resolve the conflicting testimony in the favor of the claimant. I find the claimant's testimony and the other evidence to be more logical, persuasive than the employer's, and did not submit one piece of evidence. And then it says, in the present case, it was necessary for the claimant to quit her job with the employer due to her mental health conditions. While there was a pending investigation when the claimant quit, the employer had not informed the claimant that she was going to be discharged. Moreover, the claimant's credibility testified that she was experiencing suicidal and homicidal ideations when employed. Exhausting all reasonable alternatives to quitting would have been futile, since she would have returned to the same working conditions. Therefore, the claimant had good cause to quit, and the benefits are not denied. The claimant has established a good cause to quit due to illness. then it says it was reversed. And then they could have appealed and they didn't.
Okay. And just to make sure that I understand that, because I appreciate that information, that was through L&I?
No, unemployment.
Unemployment, okay, gotcha. Okay, and so you were fighting your denial of unemployment, and then you were successful on that and getting unemployment?
Yeah, they said that I quit in lieu of disciplinary,
Okay.
which is
Thank
what
you.
they all put on here, which they all knew it was a lie.
Okay.
So then, in order for them, for the RCW 7.105.01 unlawful harassment, it was just, so last year they were only accusing me of a single act of violence or threat of violence depicted on a specific person that seriously alarms, annoys, harasses, or is detrimental to such person, and that serves no legitimate or lawful purpose. So it did have a lawful purpose, and the purpose was Jay Ainsley sent out a directive to Scott on 4/19/2018, and it told them that they need to provide an inclusive and respectful workplace. So then it says, I ask each of you to recommit to building a work environment that are respectful, supportive, and inclusive to everyone. When state employees have a workplace that they deserve, they are able to do their best at work. So this was submitted before I even started work. And before I started there was a gentleman that worked there for 18 years. And Mary and Ann and Scott all harassed this gentleman for 15 of those 18 years. So I included his resignation letter. He was having eye issues, so we work at the blind school. He had eye issues, and Mary had retaliated against him, and she had moved him out of an office that had natural glass in it. So he had to get a reasonable accommodation to be moved back into that office, and Scott came in and told him that he needs to mind his own business and he needs to do his job. And Ann, Scott, and Mary, all three of them denied his reasonable accommodation. So he was just tired of 18 years of this kind of treatment by these guys. So he quit. So I'm experiencing the same exact treatment that he was treated. They refused my reasonable accommodation, and he was a super hard worker, and so am I. So they don't like people that follow policies and procedures, because these people don't put in policies and procedures. So what this statement said was for them to identify diversity, inclusion, and equity, and Ann or Scott didn't do that. And then to identify the gaps, and they didn't do that. Track compliance, they didn't do that. Review your agency handling personnel investigation. So if they would have did the investigation, they would have found the 18 years that they knew they were harassing this gentleman. So it tells them exactly what they need to do, put in action. So all they have to do, there's an agency up at Olympia, and all they have to do is cut and paste what this agency says, put it in a Word document, and put it on the website. And these people can't take the 5 minutes that it takes to do that. So for the 3 years, I kept asking for these policies, and Ann just looks at me like I'm a complete idiot. Mary at least admits that they're there, but she says, I don't like to be a supervisor. That's why I hired you. That's your job. So that's why I was having a mental health breakdown, because I was doing Mary's job and my job. In here, Ainsley just admits that he knows that there's toxic workplaces, and he directs it to Scott, who is the bully, who is the harasser, who retaliates, and Scott just didn't do it. He didn't follow through this directive. So it's been since 2018, and these people just think they don't have to follow policies. So then they broke down exactly what they have to do. So on rules and policies, it says identify your gaps and develop work environments, put inputs from your staff. Anytime I would ask for something, that's when I would get retaliated. Scott does not like people to have needs and wants. He's a dictator, and if you ask him a question, he retaliates, and just his feelings get hurt, and then he reverses it, and he makes himself the victim. His favorite line to me is to tell me, victim, 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 all I hear is that you're a victim. And that's what he says every time I ask him, can you, Ann purposely used all of my leave, can you fix this? And Scott will tell me, Ann has other things to do, Ann has better things to do. This will get done at the end of the week. It would have taken her 5 minutes to do it, but they didn't fix it for 8, 9 months. They wouldn't fix it, so I had to quit my job because I had no leave, because Ann illegally used all of my leave. So training, it says they need to train, and there's no training. I public requested the training, there isn't any. The biggest thing, is what I'm doing is, the biggest thing on here is it says, reporting culture and processes. Lead and develop a clear expectation for reporting processes. So when there's harassment, retaliation, discrimination, hostile workplace, all of those policies, so Mary was my supervisor, so I would report it to Mary and she wouldn't do it, and then I would report it to Ann, and Ann wouldn't do it, so I'd go to Scott, and Scott wouldn't do it. So I'm reporting violations to the violators, and they just won't do it. So what my purpose of these emails is to find, where is your complaint process? Where do I go that I don't have to report my complaints to them so that they don't retaliate? So it's too late for me, but I have a lot of friends at the agency and they're being harassed. So all we're asking for is, put your complaint process in. Where is your complaint process? So it says, adopt best practices to improve pathways for employees to escalate concerns about workplace environments. And they won't do that. So I went to the board, and Scott lies and tells the board that the board is not concerned with employee conduct. No, the board isn't, but the board has the right to fire Scott, and they refuse to investigate. So in the package you saw where I sent fraud and all the documents to the board, and Kim sent it back saying something like, oh, this is alarming, I'm glad I don't have to investigate. No, you do have to investigate. When you're told there's harassment, retaliation, you have to investigate. So every time I went to one of these people, they have the obligation to investigate, and they wouldn't. So I went to the board multiple times, and so the other guy, there was a guy named Greg saying, oh, this is escalating, and he's obligated to investigate.
One more minute, you've had about 12 minutes, okay, so one more minute.
How can I only get 10 minutes when I've been sitting here for like 2.5 hours?
Well, I don't think anybody got 10 minutes of testimony today. I'm giving you the longest amount of testimony today of anybody.
The last people were here for like a half an hour.
But wasn't one person at a time. It was kind of per person. I'm not gonna give them any time to testimony. I'm gonna give you about 13 minutes.
So I have EEOC, I have all their misconduct, they have to do, retaliation is termination. I have, I filed workman's comp, I filed EEOC, I filed DOL, I filed a reasonable accommodation for them to stop bullying me, fix my errors, and I did this on 2/4/2022, and Ann refused to process this. The reasonable accommodation says that she has to process it within 15 minutes. When I went to the unemployment judge, the judge asked Ann why she didn't process it, and Ann said, I was still working on it.
Okay.
5 years,
and that's kind of
5 months.
For you. So you all work together.
Not anymore.
Yeah, you previously were together. You quit. You did, your unemployment claim was upheld. Any of the other than these cases, have they filed anything else against you in a court?
No, so
Okay,
that's.
and then what have you, and then the things that you filed against them, can you list those again for me one more time, those claims?
I filed 2 claims for EEOC failure to accommodate,
Okay,
because Ann didn't process a bunch of them. One of them she denied, and then this one sat there for 5 months,
okay.
so which was most of them.
And all of the things that you filed, what are the status of those items?
What do you mean?
Like, where are they at?
EEOC. I just asked for a right to sue letter, so that's why I have that tort filed against them in April 2023.
Okay,
So then I filed a DOL claim against them too, and then she said all she could do was tell Ann to, when you do FMLA, you have 5 days to give me a rights and responsibility, and an eligibility, and Ann never did. Ann gave it to me like 5 months later.
and so you've got 2 EEOC claims pending?
No, I asked for a right to sue. You can have them go through it, or you can sue, so I just decided
Are
to.
there any other court cases pending besides those EEOC ones where you're asking for the right to sue?
So for that right to sue, I filed a tort, so there's a tort, and
Okay,
so I filed a tort, there's a tort number on there, and they told me it's gonna be 2 to 5 years for that to go through.
okay. Okay, I really appreciate that information. There's clearly ongoing litigation that's going on. You are very frustrated with, what happened in the workplace and also the initial granting of the protection order. What I'm finding though is, that there's still communication that's being sent by you that involves them, and there's ongoing litigation, and so I can't find that there's a substantial change of circumstances, such that I shouldn't renew the protection order. I understand that you don't agree with my ruling, but I am going to renew the protection orders. How long have y'all known Ms. Freilich?
She started employment in 2019.
Okay, so you guys have known her about 5 years. Okay, I'm going to renew the protection order for 10 years. And so I'm gonna go over what the protection order says. This doesn't prevent you from presenting lawsuit with an actual credible basis. So if there's a basis for actual litigation, you are not presented from doing that. You are not allowed to present litigation or claims that do not have a credible, valid basis. You're not to harm them, you're not to have any contact with them. You are to stay 1,000 feet away from them, their workplaces, their vehicles, their residences. You're not to harass, follow, stalk, or monitor them. You're not allowed to own, possess, use, or control any weapons or firearms. It is not in your best interest to send emails to people about them, because that could be considered a violation of the protection order, and that could cause you to be arrested. So if you say, Commissioner, they violated employment laws, they violated my civil rights, they violated whatever, you pursue that claim through whatever court or agency you pursue that. But you continuing to send emails that reference them could be a violation of the protection order. They can call law enforcement and say, here's what she's doing, and then law enforcement will, or they can forward it to the prosecutor's office. In addition, I think it's gonna make you less credible with any court that you move forward in, because you're exactly doing what they've kind of said that you've done. Does that make sense?
No, all they have to do is file a complaint, provide a complaint process that is required by the RCWs, and they refuse to do that.
Okay,
So if they did that, I would have an avenue to file things, but they refuse to do that.
okay. And I'm telling you, I'm not preventing you from filing your objections and from the things that you have about those issues. But you sending these emails about them, I think you're getting really close to violating the protection order. You're sending emails saying I was homicidal due to harassment. Homicide is the intentional and unlawful killing of another. You sending those emails is threatening. You need to stop doing that, okay? I'm not telling you that you can't, if you have a valid claim, no court can prevent you from filing that. But you're not to send these emails any longer. Do you understand what I'm saying?
No, I don't, because I'm saying I was homicidal.
Right.
I was homicidal at that time.
Do you mean
but I quit.
suicidal? Do you mean
No,
okay.
I was
So, ma'am,
homicidal.
if somebody's homicidal, that means they're going to unlawfully kill someone else. That's a threat. If you say, I was homicidal, that's threatening.
I was homicidal. I quit my job because these people wouldn't process my
Okay.
harassment, retaliation.
The messages that you are sending are threatening. You need to stop sending those messages. Those messages where you're talking about school shootings and other shootings or threatenings, you need to stop sending those. I'm renewing the protection order for 10 years. It'll expire 10 years from today, May 2nd of 2034, okay? If there's violations, you guys can call law enforcement and forward it to law enforcement, or you can call the prosecutor's office and say, I wanna forward this information directly as a violation of a protection order. Do you guys have any other questions for me? Okay, do you have any other questions for me?
Yeah, so I have a lawsuit against them, and it's gonna be 2 to 5 years. So I have to do public requests so that I can support my lawsuit.
But that's not a public request, those emails,
Right.
those are not public requests.
That's right, I'm just
telling
asking you about.
You can lawfully pursue if you are lawfully allowed to do public requests, if you're lawfully allowed and you have a good faith basis for a lawsuit, you're not prevented from doing that. Those emails are not okay. Do you understand the difference between those things?
So if I take out the word homicidal, then it's fine?
But none of that email is okay. Nothing about school shootings, people being shot, homicidal, all of those are threatening. You need to stop doing that. You can say, I'm sending a public records request for this, fine. I'm filing this lawsuit. And
So
you
I
file a
take
lawsuit.
out the homicidal and the school shootings, and then those emails are fine?
I'm gonna look at the most recent one. Okay. None of this says, I'm making a public records request. So no,
I'm
none of
not,
this
I'm
email is
trying to
fine.
find somebody, I'm trying to find the alternative reporting source that this agency is required to provide.
None of this email is fine. So if you have a way of doing a public records request or a way of saying I'm requesting this information that is lawful, that's fine. These emails are not okay. In my opinion, I think they're a violation of the protection order, which could get you arrested. So I would encourage you to have somebody else look over your requests and your communications before you send them and say, does this appear threatening or harassing in any way, okay? So why don't you have a third party review all those messages before they go out? Okay, do you have any other questions for me?
I found something online that said that I could go to a judge.
Yes, you can.
So.
You can file a motion for revision within 10 days from today's hearing.
Okay, perfect.
Okay, all right, I'm gonna have you wait, okay, you three folks are gonna go, okay? And then I want you to wait for 5 minutes, okay, before you leave, okay? All right, thank you guys for being present today.
Thank you.
Okay, all right, sir, what case are you here for?
He's here, mine's until 1:30.
Great, okay, all right, I wanted to make sure, because I was like, I don't think we have enough person. Okay, let's take the last case on our docket, which is gonna